and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are Afenyo marking. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afenyo marking, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
It gives you the opportunity because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonple, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Ayariga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and presenting petition. There are no rules on that. But it's part of our practice. The majority leader will respect you. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think, majority leader, you are wrong. The rules were made with specific functionality, and the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence, and we are here saying that is normal. Why don't you take your note?
Marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime it appears to me, I'll conclude. Because you are pushing me to conclude, I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dredji. And when I have a view and I catch your eye, you must allow me to express him. I want to tell the majority leader, anytime he obstructs the minority leader, we will also obstruct him. No? Let him make his point. If it is the case that your strategy is that you are going to obstruct him, we will also obstruct you. And you won't make your point. But the begging question, to what end? Are we going to conclude this vetting? What are we telling Ghanaians as representatives of the people? Speaker, I think you should rule on this matter. The majority leader should put down his points.
Honorable,
can I finish? For heaven's sake, can I finish? The respected majority leader I saw him taking copious notes. He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else. Let him write down his points. When the minority leader is done, then he can come in. Then we can make progress. This whole strategy of any sentence.
I would have been asking questions, but sometimes when I ask questions, they take it that I'm being sarcastic. I will give the floor to Honorable Roxanne Dafamoko.
Chairman, thank you for the opportunity. Given where we are, your guidance on this matter. And here it is. Within the terms of Order 103, Rule D, Rule E, and F, the minority leader led a team of his members. They filed a motion. The terms of the motion, Mr. Chairman, reads as follows. That this Honorable House, having regard to Articles 110, Clause 1, 125 to 127, 144, Clause 1, and 146 of the 1992 Constitution and Standing Orders 57, Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule F, Order 216, and Order 217 of our standing orders resolves to suspend forthwith all further proceedings, both at the Appointments Committee and our plenary, on the nomination of Justice Paul Bafuboni as Chief Justice until all pending suits and applications directly bearing on the removal of a leadership Justice Gertrude Araba Isaba Tokonu, Saki Tokonu, including ECOWAS Court, suit number ECW/CCJ/APP/32/25 on provisional measures, multiple Supreme Court proceedings, and High Court applications are finally determined or withdrawn. And that, in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination, and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate to provide a comprehensive briefing on the status of all pending litigation relating to the removal of a leadership justice.
In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Minority
let
leader.
me finish.
With all
Chairman,
due respect.
You allowed the minority leader. I'm responding to his
asking
objection.
the minority leader to raise an issue. Order.
I am responding to I'm responding.
Honorable minority leader.
Let me respond.
Honorable minority leader, hold it. Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second.
Minority leader, let your microphone be off. Hear me out.
Very well. I will hear you.
I'm supposed to play the fair game here.
If you make your point, we respond.
Honorable minority leader,
What is wrong?
Please, just
don't want to
observe
respond.
me.
The Flame Post spoke.
Hear
for
what I
almost
will want
20
to
minutes.
say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been-
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
No, I have the floor. You've not called me.
Chairman, the rules.
You have not called him. Chairman, you see, Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. So when you
Just comes in. But you just put on your microphone and speak. Leader, you
The whole world is watching us. You will not have the floor until I ask you to do so, without the speaker asking you to say something as disorderly. And I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement. If we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in.
Yes, hold it.
Okay,
Not
no
for
problem.
him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee. Because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.
You see, when your leader is speaking, and you're asking me to give you the floor.
The majority leader has raised this issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch his attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application